person in your opposition to the so-called insular cases because of their effects on Puerto Rico. But for almost a decade, the government of America Samoa has invoked the insular cases in court to protect what they call the Samoan way of life. Just last week, Judge Carlos Lucero of the 10th Circuit agreed with the America Samoa, saying, quote, "The flexibility of the insular cases framework gives federal courts significant latitude to preserve traditional cultural practices that might otherwise run afoul of individual rights enshrined in the Constitution," end of quote. What effect would your constitutional position have on an unincorporated territory like America's Samoa that has relied on those cases for almost a century to preserve both its unique culture and its American sovereignty?
Senator, the insular cases that were decided in the early part of the 20th century were based on racist underpinnings, and the Supreme Court that decided those cases was basically the same Supreme Court that decided Plessy versus Ferguson. So my criticism of those cases is in the historical aspect. Now, as a sitting judge, and if confirmed to the Court of Appeals, I will continue to be a sitting judge, the question you have posed is a question that is currently before the 10th Circuit. It was, as you correctly stated, it was decided last week. It may be an en banc sitting that may be asked by the parties or may go to the Supreme Court. So as a sitting judge, I do not think it's proper for me to answer that question. But I hope my earlier answer has at least added something to my response.
You have written and spoken extensively on Puerto Rico's territorial status under the Constitution, denouncing it as colonialism. You even wrote a book about it. Will you commit to recuse on any future cases involving Puerto Rico's territorial status, given your extensive commentary on the issue? And let me continue to ask another question along that line. Could you point me to any territorial status cases where you have held the law compels an outcome different from those you have advocated for in your writing?
Senator, I have had, over my 15 years experience as a district judge, several cases involving the constitutional relationship between Puerto Rico and the United States. That is a very small fraction of my overall docket. I have always upheld the Constitution and laws of the United States when resolving the issues pertaining to Puerto Rico's status, even though those issues may be adverse. And in most occasions, my rulings have been adverse to Puerto Rico's citizens or status, but I apply the law to the facts of each case. If the issue of recusal were to come before me, it's an issue I have to decide on a case-by-case basis. I have made expressions regarding the territories as part of my opinions, but it's been these expressions have been made based on matters that have been raised by the parties in the proceedings before me. Like any other case, I will look at the Code of Judicial Conduct and determine on a case-by-case basis whether recusal is warranted or not.
My last question for you. You had a case regarding disability payments in Puerto Rico where you ignored a 1980 Supreme Court judgment that Congress should prevent each payments by saying, prevent such payments by saying your court cannot simply bind itself to the legal status quo of 1980 and ignore important subsequent developments in the constitutional landscape, end of quote. One such subsequent development you identified was the gay marriage case of Windsor. This is in stark contrast to what your mentor, Judge Jimenez, said in Puerto Rico gay marriage case. He addressed Windsor saying that he, quote, cannot see how any doctrinal developments at the Supreme Court changes the outcome of prior Supreme Court precedent or permit a lower court to ignore it, end of quote. He waited for the Supreme Court to overturn its precedent. He didn't do it at a trial court. Was Judge Perez wrong?
Senator, the case you're referring to is now before the U.S. Supreme Court. That's United States versus Baello Madero. And I have to note that there are very similar challenges presently before me and other federal judges. So in that respect, I should not give an opinion about the case. I do want to note that when I decided Baello Madero, which has been confirmed by the First Circuit, is now before the Supreme Court, the arguments that were raised before me were arguments that had not been made in the 1980 cases. So I resolved those arguments that had not been raised before, and those are the arguments that will, I assume, be before the United States Supreme Court.
Thank you very much. And
Thank you, Senator.
Congratulate you on your nomination.
Thank you, Senator Grassley. Senator Hirono is recognized for 5